This is another lecture in the series Principles of Ethics created for philosophy classes at Shenandoah University. This is the second part of our 8th lecture, which considers the principle of justice. Our concern here is the relationship between justice and rights. You should recall that the principle of justice requires us to treat people as they deserve to be treated, to give them all that to which they are entitled, and to treat them fairly. You should also recall that justice is particularly relevant to our evaluation of institutions. This podcast focuses on the relationship between justice and rights. Rights would seem to be the primary language of justice. When we talk about justice, we often talk about people's rights. The second issue we want to look at is the relationship between this language of rights, so important in talk about justice, to the moral principles we are using in this course. Let's begin by thinking about what rights are, looking at some standard definitions of rights. The Oxford Companion to Philosophy says that rights are justified claims to the protection of persons' important interests. It says that rights are owed to persons for their own sake, and that they are essential to human dignity. The first and last part of this definition is particularly important. Rights are justified claims that we make upon others to protect our important interests. And don't we seem to believe that our rights are essential to our dignity? That is to say, when our rights are violated, our dignity is offended or abused or disrespected. My own definition of a right would go something like this. Rights, it seems to me, define a person's or a group's legitimate expectations of others. To say that we have a right means that we can justifiably expect and demand a particular type of treatment from others. Put differently, rights generate obligations. If I have a right, that means you have an obligation to respect that right, and I have a legitimate expectation that you will respect it. Lawrence Hinman's definition of rights makes an important contribution because of its distinction between negative and positive rights. Negative rights, he says, are entitlements to do something without being interfered with, whereas a positive right is an entitlement that obligates others to do something that assists us or on our behalf. Let's look at this distinction with a bit more care. And let me suggest that the way to understand it is in terms of the obligations that correspond to the rights that we might name. Negative rights are those which prohibit some action or interference. In other words, the obligation related to that right is negative. It tells us we may not do something. Positive rights, however, are those which require some kind of assistance. If I have a positive right, then you must do something to assist me in the fulfillment of that right. Now, we have said that justice has primarily to do with institutions, like our government, for example, and that rights is the primary language of justice. So let's apply that to government here. Government's obligation to respect our negative rights means there are some things governments may not do. On the other hand, if we have positive rights, that would require our institutions, including our government, to do certain things on our behalf. Negative rights are respected or observed by doing nothing. Those rights that we have that we understand as negative protect us from interference or from interfering action on the part of others. Many people believe that our most basic rights are negative ones. That is to say, the most important expectation that we have of others, that we have particularly of institutions, is that they will leave us alone, that they will not interfere with us as we think and act in pursuit of our own particular self-interest. Such a view would be one that regarded our capacity for autonomous reason, for thinking, choosing, valuing, and acting for ourselves, as the essential defining characteristic of our humanity and of our dignity as human beings. Now, some examples of rights typically understood to be negative ones are things like the right to life. A right to life means that we legitimately expect others not to kill us for no good reason. Our right to liberty, again, it means that we expect others not to interfere with us without justification. Our right to pursue happiness means that we should be able to live our lives and make our choices without undue interference. Or consider something a bit more concrete and easy to talk about, our right to free speech. What it means is that others may not interfere with us when we attempt to give expression to our views about things, our beliefs about things. Now, by contrast, the obligations that correspond with positive rights are ones that require someone to do something for us or on our behalf. They are not met simply by staying out of our way or not interfering with us. If a right is a positive right, it means someone must do something, someone must come to our assistance in some way. Now, these are clearly more controversial for a variety of reasons. I mean, obviously, they are more demanding and thus would seem to require a deeper, more convincing justification than negative rights. They are also controversial because others, our institutions, our government, may not always be in a position to be able to provide the positive assistance that a positive right might require. Some believe that our basic rights are rights that can always and everywhere be respected, but positive rights require resources that may not exist. So, what are some examples of claims, of positive rights claims that people sometimes make? Well, consider the possibility of a right to health care or a right to food. If such a right has any meaning at all, it is a positive right. That is to say, those who claim a right to health care or a right to food are claiming that our institutions have a responsibility, that our governments have a responsibility to make sure that we all have access to health care or access to other basic necessities like food or housing. Well, that's probably a far too brief introduction to the distinction between negative and positive rights. Hopefully it's enough for you to understand the concept. Let's turn to another distinction that sometimes is made, the distinction between general versus special rights. This distinction may be understood in terms of who has the rights and what is their basis. General rights are those that all persons are thought to have in relation to all others, where special rights are based upon the special or particular relationships between specific persons. Those rights that all persons are thought to have in relation to all others are sometimes called human rights. We have them simply by virtue of being human beings. That's their basis. Something about our common nature as human beings justifies our expectation of particular kinds of treatment. Soon after World War II and the founding of the United Nations passed a declaration on human rights. Here are some of the things it identified as rights that all people enjoyed and that all people were obligated to respect. A right to life, liberty, and security of persons. A right to freedom from torture or other inhumane treatment are among the many rights identified in the Universal Declaration as human rights. Now, special rights are owed only to particular people and their basis is in the specific role relationships or agreements and contracts that exist between particular people. Citizenship rights may be understood as special rights. That is to say, the rights that only those who are citizens of some particular political community or some particular nation are thought to enjoy. Customers may have certain rights. When one is made a guarantee in the purchase of a product, that guarantee produces certain specific rights. Husbands probably have particular rights in relation to their wives, and wives in relation to their husband. Or consider the right important to so many and controversial for others to bear arms. Almost no one argues that that's a universal human right. Rather, the claim is made that it is a right guaranteed to the citizens of the United States in our particular Constitution. It's a right of citizenship in the United States. Well, now you have some basic understanding of what rights are and some of the different categories of rights. Let's turn to a different question now, and that is the relationship between rights and principles. In this class, we're using a system of 5 principles to analyze cases, but now we're talking about rights. What is the relationship between these rights that we might claim to have and the principles that we are using for analyzing cases? Let me suggest first that the question of rights and principles is largely a matter of focus. If we were focusing on the persons who are affected by our actions or by someone's actions, then we would talk primarily about rights. Remember, rights are a person's legitimate expectations with respect to how they are treated by others. So when our focus is on the persons affected by actions, our question would be, what rights does he or she have? But our focus is elsewhere. You will be asked in writing your case studies to focus on what a particular person should do. So our question is, what are the moral principles that define that individual's obligations? Were our focus on the one acted upon, we would talk about rights. Rights define the legitimate expectations of those being acted upon. But our focus is on the actor, and our focus will then therefore be on principles. Of course, we should not exaggerate the difference. Talking about principles and rights may be simply different ways of saying the same thing, or different ways at expressing our moral convictions, but from a different perspective or focus. Recall when I talked about rights, I said that rights correlate with duties. That is to say, if one person has a right, then others have an obligation related to that right. The obligations correlated with particular rights can be talked about in terms of principles. So if we were to say someone has a right to life, that means others have a duty not to kill, which we talk about in terms of non-maleficence. Or if one were to affirm a right to health care, that would be a positive right, which required others to act on our behalf or in assisting us. That we could also talk about in terms of the principle of benevolence. Our right to free speech protects us from undue interference, which we could talk about in terms of other people's duty to respect our autonomy. Our claim that we have rights over against the various institutions that affect us, particularly our government, could be spoken of simply in terms of their duties of justice. An important issue to understand here, where our focus is on what a particular actor should do, is that his or her rights are largely irrelevant. Having a right to do something does not mean that one is right in the exercise of that right, or that any exercise of that right is morally appropriate. Consider, for example, if someone complained about the inappropriateness of something you had said. For you to say, but I have a right to free speech, would be irrelevant. Simply because you have a right to free speech means that others cannot interfere with you. But that does not mean that everything you say is morally right. Our concern in the cases is not what you have a right to do, but what it would be right for you to do were you in that situation, or what is right for the person in that situation to do, not what his rights are. When we are considering what someone should do, his rights are irrelevant, but the rights of others are what matter. The rights of others define my obligations, not my rights. Consider, for example, the case of Mrs. Jones. Remember the Catholic woman with 8 children who, during her 9th pregnancy, discovers that she has uterine cancer. Remember, if she has the surgery that would save her life, it would destroy her fetus. And we wonder, what should she do? Now, her own right to life is largely irrelevant. That right correlates with a duty that the rest of us have, not to kill her. The relevant right in this case is a potential right to life that her fetus might have. Now, in saying that her right to life is largely irrelevant, I am not denying that she may have some kind of moral responsibility to preserve her own life. I'm saying only that we would not normally talk about that in terms of her right to life. Her right to life defines our obligations in relation to her, but not her obligations in this particular case. Many of us would agree, I'm sure, that she has some kind of a duty or obligation to preserve her own life. It may be an obligation that's ultimately grounded in her being able to meet her responsibilities to her husband and children. But even if we were to say, apart from those relationships, she has some kind of an obligation to preserve her own life, we would not normally talk about that using the language of rights. Again, but not to belabor the point, her right to life points to the obligation of others not to kill her, but says nothing about her obligations in relation to this very difficult choice that she faces. Well, this concludes our discussion of rights, which I have said is the primary language we use in talking about matters of justice. I've also tried to clarify a bit about the relationship between rights language and principles. As I've said, our focus in this class is on principles, but there is a close relationship between principles and rights. If you have further questions, we will hopefully have the opportunity to clarify those in class.